Okay, guys, let's get started. So I'm very excited for this debate right now between Judge Posner and Professor Epstein. And so what I'm going to do is I'm going to announce our moderator, and that's Olivia Luck. Her full bio is in your packets. She's an attorney at Nairo, Haller, and Nairo, where her practice focuses on patent and other intellectual property litigation. She has a law degree from Washington College of Law and a chemistry undergraduate degree. Before going to law school, she was a patent examiner, and she's also the co-founder of the Richard Lynn American Inn of Court. So, Olivia?
Welcome to PatCon 3. I'm thrilled to be here, and I'm thrilled to help host or moderate this friendly debate. I know the two gentlemen up on stage need no introduction with this group, but I'm going to give you a short summary of their bios. Judge Richard Posner majored in English at Yale before graduating from Harvard Law School magna cum laude in 1962. Following his graduation from Harvard Law, Judge Posner clerked for Justice William J. Brennan, Jr. From 1963 to 1965, he was assistant to Commissioner Philip Elman of the Federal Trade Commission. For the next 2 years, he was assistant to the Solicitor General of the United States. Judge Posner served as general counsel of the President's Task Force on Communications Policy prior to teaching at Stanford Law School as an associate professor in 1968. He first came to the University of Chicago Law School in 1969 and was a Lee and Brenna Freeman Professor of Law. He was nominated and confirmed to the U.S. Court of Appeals for the Seventh Circuit by President Reagan in 1981, where he served as chief judge from 1993 to 2000. In his 30 years as a judge, he has published more than 2,700 opinions. Judge Posner has written a ridiculous number of books, so I'm not going to list them all here. We're not starting yet. While most cover law topics and legal challenges like antitrust law and the federal courts challenge and reform, he's also written books on the Clinton impeachment and Bush v. Gore. There are a few titles that caught my eye: The Little Book of Plagiarism, How Judges Think, and most notably, Sex and Reason. You can find a long list on his Wikipedia page. His latest book, Reflections on Judging, will be published this fall by the Harvard University Press. Judge Posner was the founding editor of the Journal of Legal Studies and, with Orley Ashenfelter, the American Law and Economics Review. He was president of the American Law and Economics Association from 1995 to 1996. He's received honorary degrees from leading American and foreign universities, along with a number of awards from, among others, the U.S. Department of Justice, the Federal Bar Council, the John F. Kennedy School of Government at Harvard University, and the American Law and Economics Association. Please help me in welcoming Judge Richard Posner. I'm going to do Professor Epstein's bio first. Sorry. Professor Richard A. Epstein is the James Parker Hall Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago Law School. Professor Epstein started his legal career at the University of Southern California, where he taught from 1968 to 1972. He served as interim dean of the law school from February to June 2001. He is also the Lawrence A. Tisch Professor of Law at New York University and the Peter and Kirsten Bedford Senior Fellow at the Hoover Institution. He has been a member of the American Academy of Arts and Sciences since 1985 and a senior fellow of the Center for Clinical Medical Ethics at the University of Chicago Medical School since 1983. He served as editor of the Journal of Legal Studies from 1981 to 1991 and of the Journal of Law and Economics from 1991 to 2001. He, too, has written many books and articles, many of them on legal topics. Here are some of my favorite titles: Supreme Neglect, Mortal Peril, Our Inalienable Rights to Health Care, and Bargaining with the State. Sadly, as provocative as his book titles are, I could not find one with sex in it. Professor Epstein received an A.B. from Columbia College, a B.A. from Oxford University, and an LL.B. from Yale University. Professor Epstein received an LLD.HC from the University of Ghent in 2003, and while some of you may know what an LLD.HC is, I had to look it up. It's an honorary doctorate degree, HC meaning honoris causa, for the sake of the honor. Professor Epstein was chosen in a recent poll conducted by the magazine Legal Affairs as one of the most influential legal thinkers of modern times. Please welcome Professor Richard Epstein. Judge Posner last July wrote, "Why there are too many patents in America?" Professor Epstein responded, Richard Posner gets it wrong, and patents are not the enemy. We are thrilled to have both of these authors here today to duke it out in person. So here's the format. Judge Posner is going to have 14 minutes, and then Professor Epstein will have 14 minutes to respond. After that, we'll have 5 minutes of rebuttal each, and then we're going to open it up to questions. So please take some notes. Judge Posner, please.
Oh, yeah, let me take my clock out and put it there.
Thank you very much. Pleasure to be here. Whoops, feedback. I just want to note the time so I won't go over my 14 minutes. Okay. So I have a long-standing academic interest in intellectual property, including patents. There's a huge academic literature on patents, patent system, patent law, and so on. I don't know it all, but I have read extensively in it. But in addition to that, well, ever since I became a judge more than 30 years ago, I have volunteered to handle litigation in the district courts of the circuit, mainly the Northern District of Illinois. And for the last, I think, almost 10 years, I have done almost exclusively patent cases. So I've conducted bench trials in patent cases and assisted in settlement and conducted pretrial, Daubert hearings, claims construction, and so on. I have prepared several cases for jury trials, but they fizzled out. A lot of cases, of course, settled before trial. I was disappointed. I really wanted to see if it is possible to make a patent case intelligible to a jury. I had a case that was all set to go for, it actually settled on a Friday before the Monday when the jury would be selected. It involved an encryption device for garage door openers, and the encryption device consisted of a string of binary numbers. And the great challenge, I thought, was going to be to explain binary, trinary numbers were also involved, to a jury. So I think we'd all agree, I'll be interested in what Professor Epstein has to say. I think we'd all agree that patents should not be granted unless there is a significant invention which, unless patented, either would not be developed at all or it would be developed much later. And that if that condition isn't satisfied, it's a mistake to grant a patent. And the reason is that a patent is a monopoly, and a monopoly causes economic distortions. But beyond that, the patent system, the administration and litigation of patents is very, very costly. And the basic reason for that is that a patent is very unlike a kind of standard property right. If you think of a property right in a piece of land, you see the land, you know what its boundaries are, and so on. You know what the property is over which you have a right. But an invention is an abstraction. And I had a case, for example, in which the patent that the patentee was trying to enforce had never actually been used to make any product. And the prior art that the defendant was using against the patent also was a design that had never actually been implemented in a product. So there was an extreme abstractness to the notion whether the patent had been infringed and whether it was valid. Now, there are situations in which this condition that I gave, that the invention wouldn't be made or made in a timely fashion otherwise, are satisfied. And the best example is pharmaceutical drugs, because pharmaceutical drugs are very, very expensive to develop. It's not so much the cost of the research, it's the cost of the testing that's required by the Food and Drug Administration before the drug can actually be marketed. And these tests, they're costly and they're also very protracted. So the company may actually spend hundreds of millions of dollars developing the product before it's approved for sale. Well, when it then starts to sell it, the cost of production, which is also basically the cost of duplication by another drug company, is very small. Many very important drugs are really simple chemical compounds. They're cheap. The raw materials are cheap. Production is inexpensive. So you have a situation where if there were no patent protection for the drug's inventor, it would never be able to recoup the cost of its invention in the price of the drugs, because it would be competing against copiers or duplicators who, not having borne the upfront invention costs and testing costs, would be able to make very good profits at a price far below the price that the inventor would need in order to recoup its expensive invention. So that's the clearest case for patents. But it seems to be a rare case, and when you look across the whole economy, the whole range of possible inventions, you find that very often, I think most often, the inventor really doesn't need patent protection in order to have an adequate incentive to invent. And there are a variety of reasons. One, of course, is that in the invention, the inventive process may not be very costly. There are industries in which invention takes the form of incremental improvements. The companies have staffs of engineers. The engineers work on the product and tweaking it and making it a little better and so on. And they'll do that anyway. They don't need a patent to incentivize them. In addition, there are many, many situations where the costs of duplication are actually very high, often for reasons that are not obvious. One is the learning curve phenomenon. So the inventor will be the first to start manufacturing the product embodying his invention. And at first, producing a new product, it's difficult, training the workforce, finding the most efficient methods of production, this and that. But as production goes on, the cost of production falls, and that's moving down your learning curve. You learn more and more, and your cost of production fall. Well, the copier, the duplicator, he comes into the market afterwards. Takes him a while probably to decide whether he wants to try to duplicate this product. And then if he decides to do it, well, all right, he's now on the top of his learning curve. So he's going to be at a cost disadvantage with the inventor, the first in the market. Also, very often, customers will have adapted to the initial invention. They would have established a relationship with the inventor-producer and are reluctant to switch to the newcomer. He doesn't have a record. He just started making this product. He's not the inventor. And that'll tend to protect the inventor without aid of patent law. Also, and related, is the fact that the public may get accustomed to the original product, to its trade name, its brand name, before competitors come into the market, and there's an inertia there, and customers will stick with the familiar product. That'll make it hard for competitors to break in. In addition, a lot of products simply have a very short shelf life in the sense that the invention is not going to be something that's going to be around for a long time. It's product for this year and next year, a couple of years after that, but then it's going to be replaced by something else. And so by the time someone gets around to deciding, well, this is a successful product, I think I'll make it, it may be too late because the product is going out of fashion. And then finally, of course, there's trade secrecy as an alternative to patent protection. For many products, it is very difficult for a duplicator to figure out how to make it without access, inside the plant, inside the company, the inventor. Now, trade secrecy is a two-edged sword because, on the one hand, it's a cheaper alternative to patents as a way of protecting your invention. On the other hand, it denies the rest of the inventive community of the information which is conveyed by a patent, because patents have to be published, and the publication has to include a description of the product and the process of manufacturing and making it that actually is a step-by-step recipe for how to make it. Now, of course, another company can't make it without a license from the inventor, but he may be able to learn a lot from the patent to be able to invent around. That is, create something that's very similar but not in infringing. But this is a good point. This is a good point at which to move to some of the things I've learned in my experience as handling patent cases. So one thing we learn is that the concept of inventing around, or a kind of partial duplication that is not an infringement, is not a congenial concept to jurors. Jurors think inventing around is a sneaky thing. It's copying. That is one of the reasons why patentees like juries. Because juries, partly because they don't buy invention around, and partly because they like inventors. They think inventors are great. You have the inventor, he's the plaintiff, and you have some copycat, So there's been a sharp movement in favor of demands for jury trial, and if the patentee is seeking damages, he has a constitutional right to a jury. Because of the attraction of the patent as a source of monopoly power, we have a huge proliferation of patents. Now, of course, the Patent Office and the district courts, the Federal Circuit, try to stem the flow, try to make sure the patents are valid. But even if the patents are valid, they may be serving not to provide necessary incentives for invention, but as business weapons. And just by coincidence, yesterday, I got an email from a former law clerk of mine, a little article about a patent suit in Miami, where and this is a suit between Apple and Motorola. And what this district judge said, and I'm not vouching for it, I don't have anything, but I think it's interesting. It says the parties have no interest in efficiently and expeditiously resolving this dispute. They instead are using this and similar litigation worldwide as a business strategy that appears to have no end. The judge went on to blast the company's obstreperous and cantankerous conduct in refusing to streamline the 12 patents and over 180 claims currently involved in the lawsuit. And then he said, without a hint of irony, the parties now ask the court to mop up a mess they made by holding a hearing to reduce the size and complexity of the case. So we have companies amassing huge inventories of patents, which they wheel out as a basis for challenging their competitors. One of the reasons this has become so intense in the software industry is that this software industry is very dynamic. It's very volatile. No company, no matter how big you are, your Google, your Microsoft, your Facebook, your Samsung, whatever you are, you don't know how long you're going to be there. You might be knocked out in a couple of years by a company that doesn't even exist yet, or one of your big competitors may gain a decisive advantage and drive you into the ground, because all sorts of successful computer companies have gone down the drain. So once you feel that your survival depends on aggressive accumulation and enforcement of patents, well, of course, that's putting pressure on your opponents. And so you have the kind of battles we've seen between Apple on the one hand and Motorola, now owned by Apple, now owned by Google, and Samsung and HTC and so on. Very expensive stuff. We have, of course, the patent trolls. I've had several patent trolls. I like the patent trolls. They, they're sort of buccaneers, they're highwaymen, but they're, good-natured about it, and they have a good time. I actually had a patent troll who was a very skillful inventor. And he got patents, which, he had a problem of fraud on the patent office, but, he was a real inventor. But he had absolutely no interest in making anything. He just used his inventions, as a way of demanding a license from an infringer. And of course, in some industry, and actually software is one, very difficult to do a patent search because of lack of standardized vocabulary in the patent office. But as I say, patent trolls are fun. So we have the patent trolls, we have the defensive use of patents by accumulation of a large inventory. We have patent races. So because the patent is a winner-take-all system, you can easily have a situation in which the aggregate expenditures on getting a patent by a bunch of competitors exceed the value of the patent. Now, the patent race will get the invention, because of its winner-take-all character, we'll get the invention made earlier, but you have to trade that benefit, against the cost of the race itself. Well, and I'll conclude, I just have 3 minutes, but I have become very, very conscious of the difficulty of patent litigation for judges. And let me say, actually, contrary to the judge in Miami, I have found the patent lawyers that I deal with to be entirely cooperative. It's a very, very able bar. It's really an elite bar, and it's a pleasure to deal with them, whether they're trolls or whatever they are. They're fun. But still, there's this: how on earth do you explain a mathematical algorithm? My binary encryption algorithm, or how do you explain software? How do you explain how components of a handheld device work? I had a case recently. Unfortunately, it's settled. It looked like a really fun case involving an ingredient in margarine, and I heard in a Daubert hearing a testimony by a biochemist. And I realized that the science of nutrition is actually, or the biology of nutrition, is actually more complicated even than software. So how does one fit this technology of unprecedented complexity into the jury trial? And I've really struggled with that, but what I have done, and I don't know why judges don't do it more often, but I have decided in every jury case I will appoint my own experts. So the parties can appoint experts, obviously, can hire experts, but I will appoint experts who will be neutral, and I will tell the jury, these are my experts. They're beholden to no one. Their fees are being split 50-50 by the parties. Parties cannot question the fee. And they're going to explain to you the technology. And in some cases, they will also have a view on, issues like prior art and validity, as relates to validity. So that's one thing. Give the jury some anchor by letting them have someone they can listen to without fearing that this person is just a hired gun. The other thing I've done has to do with with the instructions. So in one case, which I hoped would go to trial but didn't, the parties submitted instructions. I always make them submit the instructions well before the trial, and I have the instructions conference before the trial, and I rule on all the evidence before the trial. And for one thing, that means the parties have a very exact sense of what the trial is going to be like. That, of course, facilitates settlement. So they submitted 110 pages of instructions. So my law clerks and I threw them away and wrote our own instructions, 10 pages. And these instructions had no jargon, either of patent law or of technology, and showed it to the lawyers, and they said, fine, right? So I think there's a great deal that can be done to make the trial process more effective, even in jury cases. And we have a great experiment going in the federal judiciary. The several districts, including the Northern District of Illinois, have been selected for a 10-year study of the difference it makes if district judges are allowed to volunteer to take on a disproportionate number of patent cases. And so you develop a semi-specialization at the district court level to complement the specialization of the federal circuit. And I think it's very promising because the young, ambitious, very smart judges tend to be the ones who volunteer to do this. So you're matching the most difficult cases with the ablest and most energetic judges. So I think there are improvements that can be made in the process. But I think more fundamentally, we need to make sure that the patent law and its administration by the Patent Office and by the courts is, and also Congress's determination of basic structure of patent law is conscious of the danger of over-patenting. In particular, the notion of having, 20 years for all patents and then 25 years for drug patents, that I think should be re-examined. I think there are many industries in which either no patents should be allowed or the terms should be much shorter. So, thank you.
I believe that your timer was different from ours, so Professor Epstein is going to get 20 minutes for his argument.
I don't know if I'll take it.
Okay, that's fine. No.
Which is set at 14.
Sorry.
We'll see whether or not my clock runs out. Anyhow, it's interesting. Judge Posner began with a discussion of his direct contact with the patent system. I've never tried a case. I've never actually argued a case. I have been patent counsel behind the scenes in a fair number of cases and have worked on a number of legislative reforms on it. And the question of perspective actually, it seems to me, matters a great deal in the way in which you start to evaluate these cases. I regard litigation as the tip of the iceberg, and that the really essential portions of the patent system are how it is you design the basic institutions so that you can commercialize and develop and utilize patents short of litigation by creating a set of sensible rules and property rights, sensible set of rules with respect to remedies and so forth, which will allow you to make sure that as few cases get into the hands of deadly judges and neutral experts and devious counsel as is possible. And the question then is, how good is the various patent systems in achieving this particular goal? This particular point in time, it's very difficult to make that evaluation because we are in transition from the 1952 Patent Act, which I think for all of its rather modest defects was a great achievement by two great men, Federico and by Giles Risch, to the AIA, the American Invents Act, a propagandistic title for a statute which cost 1,000 times as much to implement and is probably a tenth as good as the one that it replaced, which I think tells us something about the arc of American patent law. The fundamental theorem is the more academic attention we devote to a field, the worse the field turns out to be in terms of the way it works in practice. Too many cooks spoil the brew, or whatever manner you want to say. So starting from this perspective, the question is, how do you design this system and what ought to be done with it? And here it seems to me there is a fair bit of agreement between the two of us. On the first point, there's nobody who thinks that a patent system is easier to operate with a system for land, but you have to be careful because land systems are often more difficult than you might suppose. My friend Gary Leiberkamp did a bunch of very instructive studies on title to land, sometimes measured by metes and bounds, and sometimes measured by surveying instruments, and found that the difference in the value of the land, depending upon the way in which it was measured and recorded, was often 3- and 4-fold. So that land itself has a series of ambiguities, which we tend to ignore when we start to deal with patents. Similarly, in patents, it's also, I think, a little bit more complicated. It may well be that when you're talking about pharmaceutical patents, the basic organic active molecule is relatively well defined and easily patentable, but anybody who's ever worked in this area knows full well that the people who patent the pharmaceuticals not only patent the fundamental chemical, but they sort of try to create a series of outcroppings around it with other sorts of patents, some of which are rather thinner in terms of their implication and in terms of their development. So that the opposition that we start to see in some sense is a little bit overdrawn. The patent system may not be as black and white good in certain areas as we suspect, and the land parallel to which we use is not this ideal model. There are frictions that take place with respect to both systems. The question then is, how does one start to work this particular patent system? And here it is quite clear that we also have some difficulties that are not always encountered or always encountered in the same way as it is with respect to land. The basic move, which still survives in the AIA, is the two-step shuffle, which began probably in the early 19th century with Justice Story and continues today. The first crack at the apple is we start talking about patent eligibility, and it's extremely important because it's designed to weed out categorically certain kinds of things like natural laws and ordinary language type of ideas and so forth from the patent system, so you don't have to do it case by case. And then what goes on is you have, I think, what is in many ways an extremely difficult question on the non-obvious situation, which, as Judge Posner mentions, asks you to decide whether or not the advance that you see is sufficiently large such that it would not be amenable to somebody having ordinary skills in the relevant trade or art. And this is essentially an effort to say that those things which could be easily duplicated by many individuals ought not to receive patent protection because there's just not enough of a game going on through that particular device to make it that important. It's important, however, to understand about this stuff that you can easily overplay that hand. In many cases, I think what you want to do is to have a system in which the patent rights are relatively secure, even with respect to improvements, and let me see if I could explain to you why it is I think on matters of nuance, there's something of a difference between the two of us and how we approach this problem. You recall Judge Posner said that in many cases it turns out that you really don't need a patent because there's enough out there in the world at large. You have an advantage of the first mover. You can therefore get yourself on the declining portion of your cost curve before somebody comes in. You can basically protect the patent by the use of brands and certain kinds of observations. You've got customer relations of one kind or another, so that you really don't need the patent. That's an argument for keeping the patent system. It's not an argument for getting rid of it, because what it says, in effect, is there are lots of cases where patenting is always going to be costly, and people will decide not to patent precisely because all these other advantages are sufficiently large that if you're looking at the relatively modest advantage or gain associated with the particular technique or process or substance in question, you'll be better off not putting it through the patent system. You may keep a trade secret or two. You may be able to improve customer relations or bundle it with other kinds of goods. And in fact, if you've got this kind of self-selection, what will happen is if the patent system, having some positive cost of its own, turns out to be inferior relative to the combination of these other strategies, you won't use it. And if that's the case, then we have here a kind of a self-selection process associated with the operation in which we don't have to worry that much about the way in which the patent system is going to work, because the private voluntary actions of various kinds of individuals will give us the needed protection that we have on this front. This turns out, I think, to be extremely important when you're dealing with a patent system in the way in which you evaluate patent improvements, which is a highly controversial topic today, most recently illustrated not in the American context, but in the Indian context with respect to a drug called Gleevec. And the basic argument that the court in that particular situation made was that there wasn't enough of an improvement as they perceived it over the existing technologies and available chemicals to justify a patent. And it seems to me that that's the wrong way to think about it. If, in fact, you have something which is previously patented, and that patent has expired, and it is now out there in the public domain for all to make, and you now decide to make an improvement, which is incrementally better than that which is previously there, you will not succeed with your new drug for the very simple reason that the improvement will be small enough so that it won't justify the huge price differential that takes place between what you have to pay for the generic in the older form and what you have to pay for the new form. What we do see, in effect, in many of these cases is, in fact, the new drug does quite well if the patent is giving it, and there are a variety of reasons for it, which suggests, as my Chicago colleague Anoop Malani has shown, that strangely enough, stronger protection in patents in many cases improves the total level of consumer surplus associated with their production, because those patents which are protected will, in fact, have somebody who will sponsor and develop them in the market. And then on the other side, the payment for these things are often deflected onto third-party payers, so that if you actually check the way in which drugs go once they're put into the generic space, they may have a couple of very solid years of sale, and then they'd start to decline. But the total number of units that go into the market isn't actually much greater than it was when the thing turned out to be on patent. So it's, again, a very complicated type situation, but I don't see in this particular constellation of situations here and scenarios a strong enough case to say, no, what we really have to do is to change the way in these particular patents operate and to work. Now, the argument has often been very different with respect to other kinds of patents, notably, for example, when you start to deal with software patents of one sort or another, where the argument is made that essentially the patent thicket creates the kind of blockade, which means that further innovation is going to be blocked by the defensive use of existing patents. And there is no doubt that there's some element of that which can in fact take place, but the question is, how important is this phenomenon relative to other phenomena involved? And I'm one of the people who believe that the patent thicket argument is, in fact, severely overrated. And let me see if I can indicate to you why that is the case. The first thing is, I think it's a mistake to assume that every time that you get a new patent in a given space, what it does is it create another obstacle to people to gain production. If it were just an obstacle and it didn't provide a gain, then people would simply stick with the previous existing technology and would not do anything. Ostensibly, you say, well, they might forfeit the gain that's associated with adding the nth patent. But in many cases, that's not even going to be the case, because what happens is that the new patent comes in. It's not an addition to the patents that are already out there in the marketplace. What this particular thing is a substitute for the patents that are already out there. And so you have to think of a new and powerful pioneer patent. It's kind of a superhighway that's going over the city streets, which consists of the relatively small, unorganized patents that previously existed. So there are many ways to understand this, and one of them is to say that the new patent thins out the thicket by rendering obsolete and unimportant smaller patents of less domain and pomp that otherwise take place. And it then becomes an empirical question as to which of these two phenomena is going to be more important. And I think the answer to that question is I think that the novelty outweighs the blockade situation, because there's no particular evidence in any area, even when you're dealing with something like software, that somehow or other the number of new patents coming into the field has diminished over time. And if, in fact, the blockade were the serious problem that we had to exist, we would assume that sooner or later the prospects of facing a blockade would have adverse effects upon the inventors, who essentially are critical to trying to introduce this kind of a process. So I believe, in effect, that that's not going to be the dominant problem. The second reason, or the third reason why I don't think it's the case, is one of the things that's quite extraordinary today is, in fact, the immense amount of sophistication that now takes place in the way in which people have cross-licensing agreements and have various kinds of licensing pools. And the sort of simple mathematical way of thinking of this is, if you have to figure out what the value are of 10 independent patents, when you're buying them separately, you have to make estimations as to the variance on each of them. If, in fact, the inventors themselves can pool these devices and sell them together, you have the following comparison. It's much more difficult to calculate the value of a patent portfolio when you have to calculate the variances of each of the 10 independent items independently, and it's going to be easier to calculate that variance if you look at the whole portfolio as one and have only one such estimate to take place. In addition, when you do have a variance that takes place, there are pricing mechanisms that are able to handle it, because virtually all of the people who run these kinds of patent pools are experts at patent pricing in one form or another, and there's nothing which says, when you're dealing with patents and with licensing, that what you do is simply have yourself a series of lump sum payments. You could easily calibrate the payments to the intensity of use, or you can vary them in various ways depending upon who your end users are and what the anticipated values are going to be. So as this system becomes better, the cost of putting the pools together goes down, the pricing becomes more accurate, and if you get more accurate pricing, it means there are going to be fewer people excluded by virtue of the fact that the monopoly price is higher than the competitive price. Or to put it another way, it's a kind of a familiar economic theorem which says that to the extent that you're able to have price discrimination in certain markets, those people who are only willing to pay something below the monopoly price but above the competitive price can now find some way in order to get into the system. So when I start to think about the issue of patent reform, I think about it in a somewhat different way. I start to think about it in terms of the ways in which I think the patent system has become too lax in its protection of property rights, rather than thinking in the ways in which it becomes too strenuous in their protection. And let me mention at least two of those things that we have to talk about today. One of them is the decline in the use as a matter of course of injunctive relief with respect to ordinary patent disputes. One of the things that is said, and is said quite frequently, is that it's extremely difficult to imagine to sort of measure the losses to a patent owner to the extent that somebody else engages in the use of that technology. Consequential damages are the bugaboo of virtually every theory of damages in either property or contract or tort law. There's no reason why we should think that the law associated with patent is essentially exempt from that kind of difficulty. One of the standard arguments in favor of an injunction is that if you stop the use from starting to take place, then in effect you don't have to go through the enormous kinds of damage calculations, which, as Judge Posner mentioned to you, are often a very difficult art form to achieve. So stronger injunctions in many cases will reduce the amount of damage actions that we have, which will in turn reduce the pressure that takes place on the administrative side of the system. The second point about this is when you're granting injunctions, it is not appropriate to think of them, and the traditional courts of equity never thought of them in that way, as being only an injunction or no injunction at all. There are at least two dimensions on which these kinds of injunctions have some degree. Oh, this is okay. They're telling me my time is up, but I used the wrong thing, so I'll just shut my computer off and talk for about another 3 minutes under the 17, just to finish this out. That the key feature with respect to these kinds of injunctions is they can be varied in two ways. The first way in which they can be varied is that you could make them conditional in one way or another, so that they're not absolute, and that means that you can tailor them in a form which gives maximum protection to the patent holder relative to the interference that it gives on the potential infringer. The second thing is you can marry them with consequential, rather incidental damages, which means that you can impose the injunction only after a temporal delay of a short period of time, which means that you don't threaten an immediate shutdown of a complicated business and allow somebody either to invent around on the one hand or to negotiate a voluntary license on the other so as to get rid of much of their sting. If you don't have these kinds of injunctions, and given the uncertainty about damages and the cost of their production, what will happen is people will simply flee the licensing system, which is so essential to operate, and then dare somebody to sue them. And that, in fact, is productive of the very kind of litigation that we don't want. And the second point I think that we should make as a major situation is that the law of licenses associated with patents are not simply a law of licenses that relies on consensual notions that you can trade what you have on whatever terms and conditions you could have. There are all sorts of complications as to whether or not a kind of rules on exhaustion of something take place. There are some doubts as to whether or not you can have limits on the alienation of something that you receive through a patent and so forth. And these particular removals from the pure consensual form strike me as always increasing the cost and reducing the overall efficiency of the patent system in question. And so for my last point then is, if the patent system, as I understand it, was, shall we say, amenable to incremental improvements prior to the passage of the 2011 Act, or what do we get from the Act? Well, the first thing, of course, is we don't need these guys to tell us how to run trials. We have a judge who gave a number of very useful suggestions at the end on how it is that you can handle instructions to a jury and the way in which you can deal with expert witnesses. You certainly don't have to radically reorganize, as the AIA did, the relationship between the federal courts and the patent office, putting things back, I'm sorry to say, in a situation where the forum is subject to manipulation, which is not true when you take randomly or not so randomly chosen judges in the federal court. It also means on certain kinds of areas you don't want to experiment with changes whose net positive is very unclear. There are difficulties with the first to invent rule, difficulties with the first inventor to file rule, and so forth. The usual rule is if you can't show a clean advantage to the new system, you stick with the old system rather than having to run two. So there are dangers of too much reform, just as there are dangers of too little reform. So my basic position on all of these things is not that we're in a Panglossian world where beyond improvements of one kind or another, but I do think that we are in a situation where we actually had a lot of reform which put things in reverse, which means that the patent law is not all that different from everything else. And so I'm going to stop now, and I'm going to waive both the right of response for Judge Posner and myself so we can get to the audience. Thank you.
Judge Posner, do you have any words in response to?
Well, just a minute.
We're going to time you.
We've got time.
I'll just mention one point on which I disagree with Professor Epstein. He said that in a situation in which it's possible to protect your invention without recourse to a patent, inventors will not apply for patents, and therefore the problem of patent protection for companies that don't need it will not arise. I don't think that's correct, because while a patent is a way of protecting a property right, it's also a competitive weapon. If you can get a patent on something that you would have been happy to invent without the patent, nevertheless, you have a greater power to exclude for longer your competitors, and hope they'll trip and give you an excuse to sue them, because of course we see a lot of patenting being done in these areas in which it's very hard to see why the firm actually needs a patent in order to protect its invention.
The answer to that in a sentence would be, if you're talking about patents of sufficiently low value that you can protect them without incurring the cost, the likelihood that there'll be serious stumbling blocks to somebody else, I think, is going to be
That
relatively
simply
small.
is not true.
It simply is
Not
true.
Anyway, it's an assertion, right?
Well,
These are
unlike
empirical-
yours,
these are
which is the
empirical.
divine revelation.
It's very odd if you have a patent system, as we do, premised on the notion that you grant patents in order to create incentives for invention, then to grant a patent where you don't need a patent in order to create the incentives is to create property rights that have no social function. And
No,
it's
that's
exactly-
wrong too, I think, because what you're doing is making a complete dichotomy. The way in which it started is you get some gain from the patent, independent of protection, and this may be enough to tip you over the edge. At that point, it's not a very big problem. It's just a marginal adjustment. It's not the situation where you will find, given the analysis that you gave, that people will patent solely for defensive purposes. In fact, in many cases, the ideal way to defend something is not to patent it, which is very expensive. What you could do is screw up somebody else by publishing the prior art, putting it into the public domain so as to block them in a more efficient fashion. Anyhow, we should probably open.
All right, do we have any questions from the audience?
Nah. Oh, David, why with you?
Professor Abrams. And we'll hold on for the microphone, please.
Thanks. Enjoyed the comments and especially the responses. So I'm going to, one question for each. Richard, I don't think you responded to Dick's suggestion about differing patent terms for different fields, different technological fields. How about that as the first step towards a possibility that some patents are not quite as valuable as others? And for Dick, why do you appoint outside experts, and can you tell other judges to do that too?
Well, you can certainly do that. I'll answer my question first. I'm not particularly opposed to that. The argument for it is that the expected utility of a software patent is relatively short and not long in terms of its use. And so the longer you go, the more likely the defensive use is greater than the offensive use. But the other thing to remember is the defensive use also depreciates very rapidly as well, given the fact that the alterations in the technology have taken place. The one area in which I think we do need longer patents is probably with respect to pharmaceuticals. For those of you who are familiar with the way the industry works, these are patents which, far from becoming obsolescent with age, like software patents, tend to become more valuable over time, because if you've used them for a long period of time, you now have in-the-field estimations shared by doctors and professionals everywhere as to the side effects and their overall success, so that a tested drug is actually more valuable than one that has just gone through FDA clinical trials. That number is down for blockbuster drugs to 10.5 years or so, because the 5-year boost that they gave you under Hatch-Waxman in 1984 is now too short relative to everything else. On the software side, I don't care that much. There is a categorical problem. The most important one is the distinction between business method patents and software patents in some cases is rather more difficult to draw than it appears in the abstract. So I'm not going to sit there and stand, here's thou shalt go, hier stand ich, ich kann nichts anderes tun. This is not an effort to create a schism in the Catholic Church. My question is, I don't think the gain on that side is as important as you might think. I think the loss with pharmaceutical patents today is greater than we currently acknowledge.
So you sort of agree on something.
Well, we agree on a lot of things.
What
We agree
was
the
your
earth is
question?
round, and we agree in the two-tier system.
What did you asked me something about expert witnesses? Okay, well, I can't discuss a pending case. My policy is, because had it gone to trial, would have been a jury trial. So I will appoint neutral experts in in any jury case. The reason is that I just cannot envisage what a jury does when it has competing expert witnesses.
Would you do this in malpractice?
In malpractice? In medical malpractice?
Yeah, just curious. So product liability cases?
I might. I think in any case in which there are technical issues that the jury has to deal with in some way, it's very valuable to have a neutral expert. The reason it's not done is very interesting. There was a study by the Federal Judicial Center, unfortunately rather dated, but they were curious about that. And there were several things. One is, which is hilarious, I mean absurd in my opinion, is that a lot of judges think it's inconsistent with the adversary system. Because it means the judge, it's like Europe, it's like the inquisitorial system. The judge actually appointing a witness, so that's one. The other, more practical, is it's more work for the judge. Apart from finding the experts, so in my experience, or one of my experiences, the expert, neutral or otherwise, the expert has to be made available for a deposition by the opponent. So if it's a party expert, he's protected by the lawyer for the party. So one of my neutral experts who'd never testified at all said to me, "Wait, I'm scared. What am I going to do in a deposition? Are you going to, do I have to hire a lawyer?" He said, "to protect me." So I said, "No, I will preside at the deposition, right? I will protect you."
Wow!
And in fact, the lawyers for the part, they were perfectly civil with,
I wonder why.
with this witness. But it is more work because they call you up and they have questions and this and that. I don't mind at all, but district judges are busier than Court of Appeals judges, so the district judges have to worry that it's going to be now what I did what I try to do with appointing expert witnesses, I tell the parties, you have your experts get together with each side, and you give me a neutral, right? So that way, any problem of conflict of interest is eliminated before the nominee or before the candidate is referred to me. And I think it's just very refreshing to have someone who has no axe to grind. I had an interesting experience in bench trials with very sophisticated chemistry, and so direct examination. The witness obviously has been extensively coached by the lawyer on his side, and he gives a recital. On cross-examination, he's obviously been told, say as little as you can, as slowly as you can, so you get nothing. But then in a bench trial, you can't do this in a jury trial. I mean, as a practical matter, bench trial, after they finish that really unedifying exchange, I would turn to the expert witness and I would say, what about this, what about that? And the expert witness would relax, right? Now he'd feel, okay, he's talking to someone who's not my lawyer who told me exactly what to say. He's not the enemy. He's curious, So, and that's what I would hope would be the relation between the neutral expert and the and the jury.
Thank you. Do we have another question in the audience?
Come on.
I know that this group is
I'm ashamed of you.
okay.
Oh, there's always one in the
Good
back.
question in the second row. The microphone's coming to you. Hold on. One moment.
So Judge Posner, you glossed over a large debate in the literature that I know you've addressed on the role of patents incentivizing pre-invention activity versus post-invention activity when you use the development of the invention. Now, you addressed this somewhat when you talked about testing of pharmaceutical products. So I was wondering what you thought, as well as Professor Epstein, on the relative roles that pre-invention incentivization versus post-invention incentivization, including testing, distribution, commercialization, and so forth, should play in the construction of the patent system.
Well, to the extent that the post-invention activities are essential to get the product to market, then of course it strengthens the case for patent protection and strengthens the case for elongated patent protection, because you have the problem of discounting. If you incur enormous costs for the first 10 years of your 20 or 25-year patent, not only are you deferring the receipt of revenue, but when you compare the current cost with future benefits, you have to discount those future benefits to make the comparison. So the future benefits in present value terms shrink relative to your post-invention. So, I think that's why they lengthened the patent term.
Well, they did for some. Look, I have a slightly different view on this. The stuff that you make commercialization conditional upon receiving the patent, this is not a troll, this is not a race, there's no uncertainty about who owns it, it's only a question of how much you can get from it. And at that point, it seems to me that the fact that you're dealing with a patented product as opposed to a non-patented product doesn't make that much business. The real difficulty in this business is trying to figure out whether or not you ought to enter the race when you don't line up as you do at the Kentucky Derby in particular gates, knowing that there's going to be a bell that starts. And as you well know, the real difficulties in this situation are so important that one of the things that everybody in the pre-race period often tries to do is to conceal the fact that they're actually an entrant in this particular market. They will go out and they will buy, if a pharmaceutical company, reagents for something that they're not working on in order to keep the trade secret sniffs, out of the game and so forth. I see a knowing look from our learned moderator whose clients have probably either done or unfolded such schemes. That's much more difficult. And so at that point, the real difficulty is which of the two triggers you want to use, which is something we didn't debate, and I'm not even sure what Judge Posner says about it, but the first invented to file or the continuous stuff. I think it's a very close debate, inconvenience on both, but my own instincts for this is as follows. All things considered, if I had to make one move and couldn't bifurcate the patent system, I would make it slightly longer rather than slightly shorter, because I think the length would basically get more people into the race to begin with in those areas where length actually gives you protection. And it won't alter that much things in the areas like software where I think the extra length doesn't give you much by way of return and for the same reason doesn't give you much by way of blocking power. Now we go.
Professor Lumley.
There's a severe look on his face.
So recent data by Colleen Chen suggests that over half of all patent lawsuits filed in 2012 are filed by patent assertion entities, the current euphemism for trolls, and that the suits overwhelmingly end up getting resolved for relatively small amounts of money, a substantial chunk of which goes to pay lawyers' fees. How do you both feel about the possibility of fee shifting in cases that seem weak or seem designed to be targeted to extract fees based on litigation costs rather than on the merits?
Yeah, I think that's a serious problem, and I've always loved the German system because I think what it does is it gets it right in terms of incentives. What the Germans do is they require the plaintiff to name a number, let's say $1 million, and then you can't go above that, except in very rare circumstances. And then let's suppose it comes out at $600,000. At that point, the plaintiff has lost 40% of his case. So that what you do is you calibrate the expenses to the division within that area, and I think that that would do a great deal to eliminate threatening kinds of litigation, because you don't get the situation where if I get any verdict, I get all my expenses, which is a fatal kind of discontinuity.
The problem with fee shifting in general is that the incentive effects are ambiguous, because one effective fee shifting means that if you think you have a good chance of winning, you actually will win more because you're going to get your attorney's fees. So if the trolls select their cases very carefully, it may make trolldom even more attractive.
But in fewer cases.
It may be fewer cases, or it may be that they do more search for cases because they're looking for a few good cases to file.
Yeah, one other point, of course, is I think, in effect, when you talk about these assertion entities, or whatever the term is today, if they're assignees, the social benefit, if you have a reliable judicial system, isn't in the transfer payments through the legal system. It's in maintaining the integrity of their voluntary licensing system. And so what one want to know is the extent to which these suits are a percentage of the total amount of license fees that they gather, to give you an idea of their systemic drag.
I think we have a question in the second row, please.
Thank you. So Professor Epstein mentioned some of the benefits of injunctive relief, and I guess I'd like to hear you both reflect more broadly on issues of remedies in the patent context. How difficult calculating damages is. This was one of the benefits that Professor Epstein mentioned for injunctive relief, as well as other measures of damages, variable measures of damages, from reasonable royalties to lost profits, the benefits and costs of treble damages. Your thoughts on these kinds of issues would be great.
Well, I think there are serious problems both with damage remedies and with equitable. In the damages case, in some industries, a lot of the patents are patents on components of some device. They're not the device, they're the component. And trying to value a component, you know, what did the infringer gain by incorporating this component that was actually patented and had no license? That's extremely difficult. When you do consumer surveys, what do you do? That's very difficult. The problem with the injunction, and Professor Epstein mentioned ways in which you can try to tinker with injunctive relief, but injunction can be, you know, a disaster. So if, for example, you've been found to have infringed a component, and now you're enjoined, well, what does that mean? You have an inventory, right? You have an inventory of your device that contains this component. Component may be very unimportant, but nevertheless, if you're not allowed to sell your product with that component, you throw away a huge inventory. Or alternatively, you make a new product without the component. You find some substitute or you leave it out. But again, you have to redo your production process. So that's why the injunction tends to be a punitive remedy very often in these patent cases.
There's no question that that's a very important difficulty, but I would put a slightly more optimistic spin on this. You mentioned that there are huge numbers of components with respect to this patent, and it turns out that one of them turns out to be an infringing device. Well, there is an advantage to having huge numbers of components, apart from the blockade problem, because you now start looking at the royalty estimations or the royalty agreements with respect to each of the components that are currently used. And suppose what you find out is that they vary between 1 and 3 cents per unit in this large device. At that point, anybody who wants to give you a damage reward much above that, say 4 or 5 cents per unit device, is going to be presumptively wrong, because unless they can show, I think, and the burden would be upon them, that this is a peculiarly decisive element, I think it's not going to happen that way. The other point is, when it comes to issuing these injunctions, one of the things that you can do is sort of take testimony on, is this a modularized system, at which point the substitution in of something for the non-offending part will be relatively trivial. If it turns out to be an integrated circuit, which is more complicated to deal with, it's going to be harder. And in the first case, you'd be tough on the injunction. And in the second case, you'd probably give a super competitive royalty to prevent future infringements, but would allow the existing inventory to be sold. I mean, the thing to understand about this is that you do not want, as the measure of damages in these cases, simple expectation damages. That's too low, because the key thing is to make sure that there's going to be weak circumvention. And if the worst you can be by violating a patent knowingly is what you would have been if you had paid the royalty, the temptation to run and hide would be too great.
Wait, we're out of time, but I have one question. Oh, I guess we have one more back here. Just going to entertain this.
I just have one question.
Okay.
So a couple weeks ago, the House Judiciary Committee held some hearings on abusive litigation, and they had 2 hearings. They had one that was on abusive litigation and tort, and then one on patents. And what I thought was striking is that in the testimony on the tort side, a small business trade group testified about a certain person receiving hundreds of settlements of $1,000 or more for mom-and-pop stores, for suing them for kind of very basic violations, but was able to get a lot of settlements. And in the patent context, recently we've seen a patent assertion entity that's using scanner patents to go after small companies as well as large and ask them for $1,000 per employee. So I'm wondering, in your experiences, since you guys see a lot of cases, not just in patents, but also you've seen torts and you've seen medical malpractice, what can patent law learn from those areas of law where there has been a greater experience with frivolous litigation and trying to curb it either through heightened pleading or fee shifting or some of the other circumstances.
Well, I
What
don't
can we
think
learn
you
from
could
those
learn that
circumstances?
much from the tort system, A, because the substantive rules, particularly in products cases, are often badly broken. But in very few of those cases do you have the remedial set of choices, because typically what they're doing is they're suing for damages for past injury, and the future flow and sale stuff is not going to be in there.
So I think you learn something different. What you learn is that
All people are terrible.
litigation is Darwinian. And these companies and their lawyers, they're trying to kill each other. And you have the class action is the most dramatic example of this. You have litigation that's designed not actually to get a judgment, but to place enough costs on your opponent to force a settlement. And of course, and you know, that's, I think, important in patents.
That sounds like criminal prosecution.
Where the patent aggregator, the troll, what have you, he's not really interested in a judgment or anything like that. He's interested in having a sufficiently plausible case to be able to impose greater costs on the defendant than on himself.
And vice versa.
There is a lot of socially wasteful activity in litigation. And of course, I mentioned just in passing the defense of patent, but you have a lot of companies and so on that take out patents, not because they want a patent, not because they think their product is endangered, but because they're worried that someone will come along and say, oh, I have my patent covers what you have. You don't have a patent. So that's a cause.
Okay, I think we're out of time now, or I know we're out of time, so we better get out of here for the session. Please help me in thanking our debaters.
Thank you.